I'm going to pass this off to David Sonenshein, who I want to truly thank. He joined us last year for our Criminal Law 101, and we had so many requests for a follow-up and more in-depth discussion that we have a repeat performance. Thank you, David, and welcome.
Thank you, Debbie. Hope everybody can hear me. I am going to speak today about wrongful convictions. When I spoke last year to this group, perhaps many of you were there, we talked about the criminal process in the United States and how it operates, judges, jurors, defense lawyers, cross-examination, that kind of thing. But a number of issues came up along the way dealing with evidence and wrongful convictions. And so I'm going to talk about those things today. I will give you a full disclosure, first of all. I am a member of the board of the Pennsylvania Innocence Project, whose job it is to root out, find, and then exonerate people who are factually, without any question whatsoever, innocent, but have been convicted wrongly, whether it's in state or in federal court. And so that's our subject. I want to talk about why that happens. There are a lot of myths about the criminal system, many of them generated, as Debbie said, from watching television. But also on the issue of why would an innocent person confess? And the answer is why. We'll talk about how many thousands. Why would an innocent person plead guilty? Tens of thousands. And so these are issues that I think most people don't necessarily appreciate. And so I'd like to talk about some of those issues today. So I'm delighted to be with you. First of all, throughout the United States, more than 3,600 men and women have been exonerated because they are factually innocent. That is, there is absolutely no question whatsoever that they did not commit the crime for which they've been convicted and incarcerated, many for 30, 40, and 50 years. And that is a large number, and it's only a tip of the iceberg, I will tell you. Everybody agrees on this, for the simple reason that innocence projects and conviction integrity units in DA's offices, which I'll mention in a moment, generally will only take the most serious cases. That is, the people doing the most amount of time. And remember, the innocence process for an innocent person, once you've been convicted, often can run anywhere from 4, 5, 6 to 10 years. And often we don't necessarily take cases of people serving lesser time because they'll be out before the process is over. And that's an issue about how long it takes to actually get a person who's factually innocent out of jail. So innocence projects are responsible for most of, or many of, historically, the exonerations. We also have a new development in the last 5 or 6 years with progressive district attorneys who've been elected in many large cities, in various boroughs in New York, in Philadelphia, in Chicago, in Dallas, in Houston, a number of California cities, where they have taken on the actual job that they are supposed to take on, which is to also check the quality of the convictions they get. And they've been an enormous, enormous help, and have exonerated hundreds and hundreds of people because the district attorney's office looked into some of these cases and realized terrible mistakes were made. Witnesses were intimidated by the government. False evidence was used. Exonerating evidence was withheld by the government, with government prosecutors and police knowing full well that the person was likely innocent, and those kinds of things. And so the conviction integrity units have been indispensable for the cause of getting people out of jail who never should have been there in the first place. By the way, a large number, particularly in Illinois and in Texas and some of the other states, were people who were exonerated who have been on death row. So without exoneration, innocent people would have been executed, and numbers of innocent people have been executed. That's not an opinion, that's a fact. and it's something that we have to be concerned with. Now, I want to talk about the reaction a little bit more in general about wrongful convictions before I get into the causes of them, which are 4 or 5 major causes. First of all, many of the wrongful convictions are obtained by guilty pleas. And it would beg the question for anyone, lawyer, non-lawyer alike, why would a person ever plead guilty to a crime that he or she did not commit? Similarly, as I suggested earlier, why would a person ever confess to a crime he or she did not commit? I must say, before I became a lawyer and became involved in such things, that was a question I asked. I couldn't conceive that if I were charged with a crime I didn't commit, particularly a heinous crime, that I would ever confess to it. But it happens many more times than we should be comfortable with. We'll explain why that is. As to why people are innocent plead guilty, the explanations are actually rather simple. If you are charged with a crime and can't make bail, and remember, most of the people, of course, charged with violent crime in the United States are people below the poverty line, are poor folks, and bail is set. Bail is not supposed to be designed to keep you in jail, but to make you show up. But very, very often, bail is set at a level which an ordinary person or a poor person could not possibly afford. That means you will stay in a county jail, awaiting trial. That could be for months, in some cases, years. Now, during that period of time, you will, of course, lose your job. You may well lose your children. You may lose your family. You may lose your home. You obviously lose your health care. You can imagine all the things you don't have when you are incarcerated, presumed innocent, awaiting trial in a county jail. Okay, remember, these people are so far innocent. Okay? Well, if the offer is made to you that if you plead guilty to the crime we're charging you with, or a lesser crime, and we gave you a very light sentence or probation, or a much lighter sentence than you would have gotten even if you'd gone to trial, people say, well, I want my children. I want my life. I want my job. And the better course, as painful as it might be, is to plead guilty. Now, don't get me wrong. The vast majority of people who plead guilty are guilty, okay? No question, okay? And if you are a wealthy, well-heeled, celebrity type, whatever, and you plead guilty, you can assume that person is guilty, okay? They're not doing it because they're worried about their job or their home or anything else, okay? But for the ordinary person charged with crime, particularly violent crime, they don't have those resources. And so they will indeed plead guilty. Now, there is another reason, which we'll get to a little more deeply later about false confessions, why they might plead guilty. And that is because in the United States, unlike in most Western democracies, okay, or many Western democracies, police are allowed to, and in fact, encouraged to lie and misrepresent the evidence to the suspect. An example, and this gets into why people confess falsely as well. And by the way, the Supreme Court has put its imprimatur on police misrepresenting evidence during an interrogation. The Supreme Court said a fair number of 50 years ago or more, perfectly okay. Perfectly okay. Now, what kind of lies? We have your DNA when we don't. We have 16 eyewitnesses when we have none. We have your fingerprints when we don't. We have your partner, your co-defendant has turned on you, and now it's time to make a deal because, you're going to go away anyway, etc. That is legal in the United States. If it were to happen in England, if a police officer at Scotland Yard were caught doing that on video, and by the way, in England, all interrogations are conducted on video, unlike in the United States, you lose your job. You are no longer a member of the police department in Scotland Yard. You are now doing something else. In the United States, that is not the issue. You may well be promoted for getting a confession and a conviction. So appreciate, and I'll come back to this a little later. I had the good fortune to be invited to go to Scotland Yard to observe their interrogation training, and I was talking to the captain in charge of training for Scotland Yard, and he was asking us what we do here. And I said, well, we're allowed to lie to people in order to get them to confess. He said, well, you can tell them you've got their fingerprints. You can tell them you have, right, all sorts of stuff you don't have. I said, absolutely. He said, well, you know, I'm a captain in Scotland Yard. If I were arrested in a sexual assault case and was told they have my DNA, I would plead guilty. I'm sorry. I'm career police. I would plead guilty, okay? Because I know I have no chance, okay? If that is in fact true, okay? Now, many of you might wonder, well, where's your lawyer in all this? Okay, well, the answer again, sadly in the United States, which is peculiar, once again, an outlier, not in a good way, 80% of American suspects waive their right to counsel. They're advised, Miranda warnings are given. We can't fault the police on that, okay? But 80% of people waive the right to counsel, even though they are afforded, if they want it, free counsel provided by the government. We'll get into that perhaps a little bit later. But so you put all that together, and you can imagine why we have false confessions, we have people pleading guilty who might be innocent, et cetera, et cetera. And I'll just tell you, because you'll be interviewing police and prosecutors, particularly prosecutors, after somebody is exonerated, and too often, not in every case, but too often, you will get this response from a prosecutor. Well, he's guilty. We still know he's guilty. He's the guy. But there was DNA that exonerated him. So what? He's still guilty. Okay? You hear this all the time. The refusal to admit making a mistake it's a problem. It's a problem for many professions. Doctors aren't great at it either, let's be clear. Or lawyers for that matter. But this is life and death we're talking about. In fact, if you remember the Central Park 5 case, which was the prototype of the most horrendous use of American interrogation techniques, leading to obviously the conviction of 5 teenagers, all of whom had nothing to do with the crime. We all know that now, except perhaps for Donald Trump, who still says they're guilty. But the main prosecutor in New York, Bob Morgenthau, probably the most famous prosecutor in the United States, admitted we were wrong. These were not the guys, okay? However, the prosecutor who ran the case to this day will tell you we have the right guys, even though DNA was found on the real right guy who admitted the rape or the attacks and 5 other rapes, okay? But we believe he didn't do it despite his DNA being on the victim. But these 5 guys who are not even there involved are the guys. That is too bad. It's not to me how a professional should operate. If you made a mistake, perhaps in good faith, own up. But this so often is a response that we get. Not in every case, I want to be fair, but a response that we get. Okay, so with that background, let's take a look at false confessions generally. How many are there? Well, it's impossible to know because, you only know if there's an exoneration, if there's DNA, which exonerates somebody, or a complete batch of new evidence comes in. But I will tell you this, New York City detectives and New York City prosecutors were interviewed anonymously, I believe 10 years ago or so, and stated anonymously, okay, in fairness, okay, 5 to 15% of the confessions we get in New York are false. New York's a big place. That is a very uncomfortably large number of confessions that are false. Now, many times police can tell they're false and throw them out and don't pursue it. We understand, that's great, okay? But on many other occasions, or too many other occasions, the false confession is accepted. It's often induced, and therefore we have a situation. Now, in any event, we have the whys, if you will, of false confessions. Well, remember that many of the people who confess falsely are juveniles. Many have mental illness. Many have IQs below 70. In fact, there was a Cook County sheriff on 2020, I got to say 10, 12 years ago, who said, I run the Cook County Jail. They closed down the Cook County Hospital, which is the mental hospital for Chicago. And the answer is that he said 90% of the people awaiting trial in the Cook County Jail, and this is the sheriff speaking, this is law enforcement, have mental illness or serious mental impairment. Okay? He said, we are now, the Cook County Jail is the mental health facility for Cook County, which is, of course, is Chicago and a few suburbs in Illinois. Okay? That is not unusual. Large percentages of people in jails and prisons suffer from severe mental illness or mental deficiencies, if I can use that word, not a pleasant word to use, which make them, of course, available for making false confessions, right? As you can appreciate, not to mention juveniles, as we had in the Central Park 5 case. So why would, apart from those demographic factors, why would a person, again, it seems crazy to most of us, confess to a crime which we didn't commit? Why would we do that? Okay? Well, part of the reason, or a big reason, apart from the demographics, which are big, I mean, being a juvenile, being mentally ill, obviously, is an issue. A lot of it comes from the way that police do interviews or interrogations in the United States. And I don't blame the police. I blame the training of the police. Because this has been going on now, well, since about the mid-1940s, by a group which created a method of interrogation which became adopted as universal among American police and police around the world. And it has serious, serious flaws. And that is an issue. That is an issue. And I have with me the training manual. I'm not going to bring it out because you won't see it on the screen, just to verify what I'm about to tell you. The way interrogations are conducted in the United States is the following. Police arrest the person they think committed a crime, okay? And obviously, they really believe 99.9% of the time this person committed the crime, okay? They then conduct what is called a behavior assessment interview. It's 10 minutes in an interrogation room where the officer asks sort of general questions to try to assess the level of honesty, okay, of the suspect. Now, you might say, why the level of honesty? You could be dishonest and be innocent. You could be honest and guilty. But the belief is, among the folks trained in this way, that if the person gives you dishonest answers, then in fact that person is likely guilty. That is a philosopher or a logician would not necessarily agree with that approach, but that's the approach. Now, during that interview, here's what the officer is supposed to do. The officer, remember, is supposed to assess the behavior of the suspect. Body language, words that are chosen, etc. And the reason I always have with me the manual is to, again, verify things like, if the suspect is speaking to you, I'll just move my screen a little bit, with arms folded, that's a sign of dishonesty. If the suspect doesn't look you in the eye during the interview, that is a sign of dishonesty. If the suspect protests his innocence too much, that is a sign of dishonesty and therefore guilt, okay? Now remember, in the United States, again, outlier, you are not required to tell the suspect what he or she is charged with. And often that is not done, okay? Often that is not done for obvious reasons. I mean, if the suspect knows, you can start saying, well, I wasn't there that day, right? So we don't even know what we're charged with, but we're making this assessment. Now, here's the, assuming that assessment is valid, and by the way, there have been many, many studies. No psychologist, by the way, subscribes to this, to the ability of one human being, even a psychologist, to assess somebody's character in a 10-minute interview, watching body language and the like, okay? There's no reputable psychologist who will ever say, I can do that, okay? Police will tell you, we have a lot of experience, we're good at this, we can do it. Well, they've done studies. The best most of us can do is 50-50, as you might imagine, right? Which is not good, okay, which means it doesn't work. And in fact, police have been studied as well, and they are no better than 50-50, and in fact, sometimes in the mid to high 40s. Now, that's not because they're any worse than the rest of us, but because the process they've been taught doesn't work, okay? Now, here we get to the really difficult part, okay? Once the police determine you are guilty because you are not being essentially truthful, okay? Their job, and this is remarkable, those of you who've studied science or anything else, understand that the bane of science, the bane of any legitimate inquiry is confirmation bias, okay? That is, before the inquiry, you decide on the outcome, right? This is why the New England Journal of Medicine recalls articles. This is why Lancet recalls articles. This is where there are problems, okay? And so clearly, in this situation, the police officer is told at this point, your job is not necessarily to find out what happened, but your job, in fact, is to help the defendant prove guilt. Indeed, if you look in the manual, when the defendant starts to protest his innocence or try to give information that would tell you somebody else did it, the police officer would then, and the picture in the manual is this. We all know what talk to the hand means, right? Put up your hand, stop talking, okay? Stop, we don't want to hear it. We only want to hear any things that are going to incriminate you. Well, this is what happens. And what you get out of that, of course, particularly over time, is a very difficult situation, and people are hard to resist. And it's hard to resist. Central Park 5, remarkable. The 5 suspects identified the other co-defendants at trial in their confessions, okay? The only problem is they had never met them. They didn't know their names or who they were. How did that information get into their confessions? Because the police leaked it to them, okay? Extraordinary, okay? And so this was a situation where there's enormous pressure, of course, on the police. This is often a problem that leads to false confessions, tremendous public fear and outrage, right? And the police feel enormous pressure to solve the case, which I think we all understand. But this plays into, of course, the fact that the training has not been developed to try to really more get to truth than to be able to create a confession and therefore get a conviction. Well, this has been an issue in the United States for many years. Thankfully, a large number of police departments, I shouldn't say a fair number, have now changed. And they changed to a method which was started in England. It's called the scientific method of interviewing and interrogation. And what it is a method that is designed to find out what happened, not necessarily to simply get a confession. And I was lucky enough to be invited to go to Scotland Yard about 7 or 8 years ago to observe police training, as I mentioned before. And I participated in the training of young detectives in England, in London, Scotland Yard, by the way, is a very large police department. They have 36,000 police officers. I watched the training, and they were being trained, doing mock interviews, and being videotaped and then critiqued by senior detectives. And the methodology is the following. You begin, first of all, in England, you have to tell the person what he's charged with or she's charged with. That's basic, okay? Number one. Number two, you're not allowed to lie, okay, or make up evidence, okay? Number three, the methodology begins with, first of all, significant preparation with a team. And then after that, you establish some rapport with the suspect. This is something that American police try to do as well, establish rapport for obvious reasons. But you do not tell the suspect that he is guilty and we're looking to get a confession. What you do is establish rapport and then simply ask open-ended questions and say to the suspect, tell us what happened. Give us your version. Interrupting is forbidden. Interrupting is forbidden. We want to get the suspect's version. Now, eventually, of course, there will be inconsistencies in that version, and the police will be, in fact, toward the end of the interview, confronting the suspect with those inconsistencies and the evidence that they have, right? They will do that. So it's not as if the suspect just sits there and tells a story. These are police. These aren't ACLU lawyers, okay? These are career police, okay? But what you want to do is get the suspect's story out first, and then you get to confront the suspect eventually with, yeah, but what about this? What about that? We do legitimately have a witness who saw this, has this, made this statement, et cetera, et cetera. We've got your car. We've got your license plate on CCTV. We've got video on CCTV. Obviously, CCTV is an incredibly helpful crime-solving item in England. I'm a big supporter of it. I know some people think it's a civil liberties problem. I don't see that personally at all. But it's sort of the first place British police go. And we're seeing more and more of it here, which I think is a good thing because it doesn't lie, generally speaking. Then if the suspect confesses, fine. We have got a story that is in fact confirmed. And some of you might say, well, gee, what's their record on confessions and convictions? This system began in the early 90s because England had a rash of false confession cases of children, of supposed Irish terrorists who had perfectly good alibis and were then exonerated. And the statistics show confessions are running at essentially the same level, okay? Number one. And number two, that the conviction rate remains high, remains where it was. I'll tell you something interesting though. Since the early 1990s, when respect for police and cooperation with the police in England was at sort of an all-time low, that then moved much, much higher. Now, some of you may have read Scotland Yard in the last few years had a real problem. I'm not going to soft pedal this, of corruption. There have been 2 or 3 major books and major studies in England that Scotland Yard, which I think we all think of as sort of the gold standard for policing, has had real problems in the last couple of years with some racial issues, with corruption, et cetera. But that's now in the last couple of years. I'm talking about a period somewhat before that. But in any event, now a number of American departments are doing this. LAPD has been training now for a number of years. They're robbery homicide detectives in the British method. Some large departments in Arizona are doing it. Other large departments around the country are turning to this kind of interrogation. And the reason is we want to get the right guy, right? We're more more interested in getting the right guy than getting a guy or a person. And remember, when a false confession is used, and jurors are very hard pressed not to believe them. I think we understand why that is. Most of us would be hard pressed to believe them, or find it difficult to disbelieve them. Just remember, in every one of those cases, I mentioned 3,600 plus exonerations in the last 15 years in the United States. That means 3,600 murderers, rapists, armed robbers, etc., are still out there. And that's why many district attorneys are saying our job is to catch the bad guys, right? Is to catch the bad guys. If we convict an innocent person, the bad guy's still out there. The first exoneration in Pennsylvania was a serial rape, a group of serial rapes. Guy was convicted who was innocent on a false confession. DNA exonerated him. It was the first DNA exoneration in Pennsylvania. That means there's a serial rapist still running around Montgomery County, Pennsylvania, who was not later sought by the police because they were convinced they still had the right guy. This is not the present county of Montgomery, but an earlier iteration. Okay, just to be fair. Okay, and so I think we understand that there are movements now. The group that created the method I've talked about for interrogation is, which I think has failed in many ways. Let me be clear. It succeeds many times because you're interrogating guilty people. We get that, okay? Somebody said that method is really good for getting confessions from guilty people. Unfortunately, it's also good for getting confessions from innocent people. And now we're seeing changes, which I think is very, very significant. That police are saying, you know what? We're not trying to just get convictions. We're trying to get quality convictions. And I think that's a good thing. And I think you will find that many chiefs of police, particularly around the United States, support this kind of reform. And if you talk to police who have adopted the reform, they're all big proponents of doing, if you will, do interrogation the more scientifically valid way. Okay, so that's, I think, an issue. And apparently about 25% of the exonerations in the United States involved false confessions, at least as part of the reason for the exoneration. Obviously, a false confession is often a big reason, since it's often the most significant evidence. Second big item is eyewitness identification. These are just mistakes, okay? These are just mistakes. Most eyewitnesses are not trying to pick out the wrong guy. I would be hard-pressed to imagine almost any eyewitness would want to pick out the wrong person, right? Man or woman, but they are mistaken. And again, there is so much science on this, which talks about the fact that eyewitness identification, not only in this context, but generally, is considered to be very unreliable. And again, I think most of us probably know that, and certainly the psychological studies overwhelmingly support that. So what can you do about that? And that's just a mistake. That's not somebody, trying to create a problem. Now, I think what you want to think about is this. Are there ways, and many courts have, Supreme Court in New Jersey has done that, okay? And said there are ways to try to minimize mistaken identifications. And two of the big ways of doing it are to have serial lineups, and the other is to have double-blind lineups or identity procedures. Third Circuit Court of Appeals in Philadelphia did a giant study, hundreds of pages on this issue, and agreed with the New Jersey Supreme Court. I think that's what that is, again, the modern view. And many departments are now moving to these kinds of ways to, again, we can't eliminate it because people are people. The fact is serial lineups involve the following. What we have found in psychological studies is if you do a single lineup, let's suppose 10 people, 12 people, And you all know what, the typical lineup you see on TV. People are in a room, two-way glass. There's often a height marker, 5'10", 5'11", 6 feet, like that, behind the people standing there. And they're all supposed to be chosen. Often they are off-duty police officers, or police officers are happening to be in the office. But the idea is, of course, they're supposed to look generally like the suspect. And I think that usually happens. But if you have one lineup, psychological studies will tell you, and they've studied this by doing studies where the wrong person is in the lineup, person we know to be innocent, for example, a police officer, that people will too often, pick out the person in the lineup who looks most like the person they remember who committed the crime. Okay? And that's just sort of, that's what human nature does. That's what your mind does. Now, if you have 3 lineups of 10 people, and of course it requires a lot of people involved, et cetera, okay? 3 lineups involved, and the person's in one of them, you can have more confidence that the person chosen really is more likely the person rather than the person who looks most like the other person. There's a Supreme Court case, I guess called Simmons against the United States, the extreme case, where I don't remember where it was from. It's a federal case, so I guess it was federal authorities. Ran 3 lineups. They put the guy they were going to charge was the only person in all 3 lineups. Now, you want to be suggestive? Needless to say, that person was picked out. Okay? That, of course, is wrong. The Supreme Court said you can't do that. I mean, that's just way too suggestive. It violates due process of law, et cetera, et cetera. I'm not suggesting police do that. Okay? But one way to avoid the problem is that. Another thing to do is to do double-blind identifications. That is, the officer who's involved in the investigation does not run the lineup. Again, because there are subtle ways that the officer knows who he or she thinks is the suspect, and that there are subtle ways that might influence the eyewitness. New Jersey requires both of these and more. Obviously all we're trying to do is minimize error. These are not misconduct situations by police. These are just errors made by people's minds. But that leads to a large number of exonerations as well. We find a lot of people who are exonerated later by DNA were in fact misidentified through error. And it's purely error, nothing nefarious or anything like that. I think the third item that comes up is unscientific forensic science. The interesting thing is that the National Academy of Sciences, and many of us, of course, have watched CSI and TV shows and read about this and seen forensics, and we're amazed by the remarkable things forensic folks can do, which they can. But in the last 10, 15 years, National Academy of Sciences went through a lengthy study of forensic science and found out that a fair number of the items we become too used to hearing about are really no science at all. And I think the problem, we'll see, for example, bite marks. We've all seen television shows and movies where bite marks were used to identify a suspect. Well, they were proved to be completely random and have no science behind them at all. FBI, 10 years ago, eliminated bite mark evidence, said it doesn't work, it's fake, and in fact went back over a large number of cases where bite marks were used and had to re-handle those cases. Give credit to law enforcement. When things were pointed out as being inappropriate, they dealt with it. Hair comparisons is not really a science. The law of arson. Arson experts testified for many years on the cause and origin of fires, thereby just saying a fire was in fact fire that was deliberately set as opposed to an accident. That testimony, the arson testimony, has now been completely revamped. And many people who were convicted, many men and women. Particularly, I know a woman in Pennsylvania did about 30 years for an arson that she was not arson, it was an accident. And the old evidence is now no longer used. It's very hard to find an arson expert who will use the old kind of arson evidence. And again, that has been a basis for exonerations in those kind of cases. There are many cases where shaken baby syndrome was the basis of a conviction, and now that's now been disproved in many ways as not particularly scientific. And people have been exonerated in those kinds of cases. The two that are interesting, of course, that we're probably most aware of are DNA, which I'll get to in a minute, and fingerprints. Now, fingerprints are interesting because courts will not throw out fingerprints. Courts believe in fingerprint science. National Academy of Science does not. National Academy of Science says that there is no accepted, remember, the test for an expert witness, okay, is the testimony has to be generally accepted or reliable, and the methodology has to be one that experts in that field generally accept. Well, that's not really true many cases with fingerprints, because many fingerprint experts use different markers. Some will say, I can identify a fingerprint and compare it to one we found at the crime scene, to one that matches the suspect on 4 or 5 matches in the handprint, in the fingerprint. Okay? Others say, you can't do that. You cannot get a legitimate match, fingerprint match, without 14 or 15 matches. There are too many cases where 4 or 5 does not eliminate enough people. And there's not agreement among experts on that. There was, in fact, a federal case in Philadelphia now 20-something years ago where a federal judge actually excluded, the only time it's ever been done, fingerprint testimony because it didn't pass the test of either general acceptance, which is the test in numbers of state courts, or a reliable methodology, which is a test in federal courts. Department of Justice appealed, asked for a rehearing, went back, offered more evidence, judge changed his mind, and allowed it in. I'm not aware of any other judge in the United States who has rejected fingerprint testimony. And so I think that's an issue that is really not going to come up in the sense that I think judges are pretty well convinced that even though the National Academy of Sciences may have issues, they didn't say it's completely unreliable, may have issues, that fingerprint evidence is not going away, The one kind of evidence which is universally accepted is DNA. And of course, many of the exonerations that we find were generated by DNA. That is to say, at the time of the conviction 30 years ago, DNA analysis was not available. But when a person comes forward and says, has a very good argument that it wasn't he or she, it was somebody else, and DNA is used, we find out that person is completely excluded as the perpetrator. DNA, really, the science of DNA is beyond challenge. The only way for a defendant in a criminal case to challenge DNA is to argue that the collection of it or the storage of it somehow degraded the sample or contaminated it. Absent that evidence, DNA is considered universally as the gold standard with respect to science that should be permitted in criminal cases in federal and state courts. And so you will not, and so obviously finding DNA is a very powerful fact and one that's essentially impossible to overcome, absent some remarkable explanation. Well, I was there, but I didn't do it. And unless there are other people there, it's pretty hard to win that argument. The fourth item that we get is jailhouse informants. And again, something we're familiar with from movies and TV. And jailhouse informants are an interesting group because when you think about it on its face, these should not be considered the most reliable witnesses in the world. These are people who will be in a county jail or in a federal prison or state prison, penitentiary, people doing conviction time, who will either be approached by the authorities or approach the authorities with an eye toward getting a reduced sentence, various privileges, being transferred to a better institution, et cetera, in exchange for providing essentially statements, confessions by people in jail with them as to crimes that the police would like to get a confession about. I think I ended that sentence in a preposition, apologies. Now, are they sometimes correct? Yes. Is it known that criminals will talk about their crimes, sometimes bragging, as bizarre as that is, in jail? Yes. Are there stories which jailhouse informants provide to police which are true? The answer is yes. The answer is yes. But remember, these are ordinarily induced by some sort of a benefit to the informer. And so we have numbers of cases where we have what are called serial informers. They sort of make a career in jail of informing. Now, I have no problem with legitimate informing. That to me is an important part of law enforcement, okay? You often cannot get the real bad guys, real bad people, right, without informants. That's key. And it's certainly something that should not be banned, in my view, okay? But there are numerous occasions where the informants have created evidence, that is a statement from a person who's in the same jail cell or in the population with them. And that has led to a number of situations of people being convicted of new crimes or the crimes they're awaiting trial on, when in fact the evidence, the confession actually never was made. The final one is, to me, very interesting and one we could do something about. And that's the ineffective assistance of counsel. Many of the cases of wrongful convictions, there's been a problem with representation provided by counsel. Now, let me take a step back and remind everybody of the way that right to counsel works in the United States. The Constitution, which provides a right to counsel in the Sixth Amendment, had never been interpreted to require states to provide appointed counsel for people who could not afford a lawyer until 1963 in Gideon versus Wainwright, except ordinarily in capital cases. That meant historically that many people went to trial on fairly serious charges without a lawyer, simply because they could not afford a lawyer, or the court, in its discretion in those jurisdictions, chose not to appoint counsel. That kind of thing is probably not something we should be proud of. Well, now, appointed counsel is required. Okay, appointed counsel is required. How does counsel found? How is it approved? How does it operate? Obviously, wealthy people can have the lawyer of their choice and get very good lawyers. Okay? They can get the best lawyers money can buy. And a lawyer will take a case, even though the person may not be a savory person, because that's a lawyer's job. So when you see a trial going on with counsel, the people who have paid counsel, right, they're going to be celebrities, they're going to be wealthy people, they're going to be obviously well-heeled drug dealers, organized crime people who have plenty of money. They get to hire a lawyer. All of us could hire a lawyer of our choice if we had the money. Most of us, most Americans, don't have enough money to get the kind of legal representation that you really would need when you're up against the government with all of its resources, police, FBI, whatever it might be, et cetera, and get the kind of representation that you really would like to have. I would say this, the other side of the coin is people who are very poor. And people who are very poor, generally in the United States, are given free counsel by public defender services, okay? By public defender services. And I think that's, very important. And I will tell you this, and I will disclose that for a few years early in my career, I was a public defender. And they do, I would think, rather a very, very good job. Would most people prefer to have a lawyer of their choice? Of course. But public defenders, overworked as they are, ordinarily do a very, very good job. And ordinarily, ineffective assistance of counsel claims are not usually directed, the successful ones, to public defenders. The real problem is for the people in between. And this includes working people, middle-class people, because the cost of a lawyer in a significant criminal case is enormous, and those people cannot necessarily hire the kind of lawyer that the wealthy folks get, and those kinds of people are not going to qualify for public defender services. So it's, the people in the middle, as so often happens, are in fact caught in the middle. Well, what happens in those cases is the court will appoint a lawyer from a list of lawyers the court has who are willing to take cases on appointment. The problem with the system is not that those lawyers aren't any good. That's not the problem. The problem is they are paid so little. Their hourly rate is a very extraordinarily low hourly rate, an hourly rate that no other lawyer would accept, right? There's a cap on the fee, which could be 30 times lower than the amount of fee would be charged by a private lawyer. And the resources and the time just aren't there. And so they aren't necessarily able, and many of them are very good lawyers, but they are not able to mount the kind of a defense that a wealthy person or even the public defender service with its resources, and they have investigators and they hire experts, et cetera, which are very expensive, can't be privately, don't have the ability or the time, because they have to take many of these cases because they pay so little, and that's the government's fault, not the prosecutor, but the state's fault, don't pay enough to let these defendants get the kind of defense that I think most of us would think we'd be entitled to. And so that's an issue. And in fact, in many of the cases that we saw where there were exonerations, there's a problem because the counsel representing these people didn't do some of the things that obviously a well-heeled counsel could or would have been able to do. And that shouldn't be the way it is. In England, for example, the court will appoint a barrister for you. Barristers are the very best lawyers in England. Very tiny percentage of English solicitors, British solicitors are barristers. And they will take the case of a person who cannot be paid, but they will be paid their regular rate by the British government. We do not do that. And so in England, you don't have necessarily the same kind of inequality, if you will, of counsel issues that we have somewhere in the United States. And again, it's one of those things where, once again, most of us who are in the middle don't get sort of squeezed out in that situation. The additional item is on appeals and convictions, which are very, very expensive. And I made this point last year when we talked about the criminal process. And as reporters, you often see at the end of a trial that the defendant comes out, has been convicted in front of the courthouse and lots of cameras. And the defendant's lawyer is outraged that there's been a conviction. and it says, as loudly as he or she can, we're going to appeal. We're going up to the appeals court, going up to the Supreme Court, state Supreme Court, federal Supreme Court. We have no doubt that we will get exonerated on appeal, and so this is not over. Which I will tell you, talk is cheap. Talk is cheap. I followed the appeals on evidentiary issues in federal courts for many years, and read the opinions. At least on the issues of errors of law by admitting inadmissible evidence. There are two main reasons you can appeal a criminal case, civil case as well. An error made by the judge in admitting evidence that shouldn't have been admitted, or erroneously instructing the jury. Erroneously instructing the jury in the law is pretty tricky because most of the time the instructions were written by the Court of Appeals. So they're not going to reverse a judge who simply reads those very instructions. So the bigger issue is evidence. And I will tell you, having followed these, at least in the federal courts, for many years, it is a rare case in which a criminal conviction is reversed on appeal. A rare case. In fact, many lawyers will tell their clients, don't spend the money. There really is not an issue that's going to prevail. Most judges know what they're doing. They're not going to deliberately create an error. And courts of appeals, by and large, defer to the trial court on those kinds of issues, and to the jury, for that matter. So particularly if there's a jury trial, appellate courts are in fact difficult to persuade, absent a real belief that this person is factually innocent, that in fact they're going to reverse a conviction. I will tell you, in other countries, in Italy, for example, you may remember the Amanda Knox case. When you go to appeal, you essentially get to retry the case. You can offer evidence that wasn't offered at the trial. You can make new arguments, which is why those things go on for 10 or 12 or 15 years. And in Italy, every case, as a matter of constitutional right, goes to the Supreme Court. As you probably know, in the United States, Supreme Court is discretionary in taking its cases. Same thing with state Supreme Courts. And the United States Supreme Court, I believe, has now been taking only 80 cases a year out of tens of thousands of applications. But if the Supreme Court of Italy, which has thousands of judges, I think 1,000 judges, justices, not like R9, they sit in panels and they hear every case. That, of course, the case isn't over until they hear it. So ours is a narrow scope of appeal, not necessarily a bad thing at all, and deference to what happens at the trial. And for that reason, the idea of we're going to appeal, it's going to be reversed, is sometimes happens, but not nearly as much as lawyers might want you to believe. Okay? We have a couple of minutes left. And Debbie, were there some questions?
There are. So there's a question about the ineffective assistance of counsel, I will say.
Yes. And
how there are situations where counsel maybe fell asleep or came in drunk, and and how is that not the ineffective assistance of counsel?
Well, that's a very good question. When I was practicing in Massachusetts, which is where I practiced, there were lawyers who came in who were intoxicated, stumbling around the room. I'm not going to say that was typical. It was not, happily. I remember a case where one of those lawyers was rolling around on the floor during the trial, and this is before we had metal detectors, and a weapon fell out of his pocket. This is during the trial, in front of the jury, okay? That was a pretty easy case of ineffective. Now, here's the problem with ineffective. No matter what the lawyer does, even if the lawyer, and this is Supreme Court law in the last 15 years, no matter how badly the lawyer performs, even if the lawyer commits what the court would think would be malpractice, unless that definitely affected the outcome, there is no reversal. So if there's plenty of other evidence and there's other evidence that's strong, and the court believes the defendant would be convicted irrespective of the fact that the defense lawyer didn't object to evidence he should have or he should have, didn't call witnesses, alibi witness he or she should have. If the evidence is otherwise strong, it didn't used to be the rule. This is in the last 15, 20 years. The court does not reverse, and the conviction is affirmed. Have those horrible things happened? Yes. I'm happy to say it's not typical. It's not typical.
There was another, you commented on how, I guess I want to emphasize discussion about about funding of public defenders, right? It is extremely varied, right, across states, counties, federal versus state, and I wanted you to discuss that a little bit.
Yeah, a public defender rate. Now, there are two levels of public defenders. The federal courts have something called the Federal Defender Service. And that is funded, I guess, by the Justice Department, or at least by the federal government. And that's universal, all around the United States, in all 91 federal districts. But state by state, the funding is a matter of state law and done by the state legislature. And some states fund it very poorly, and some states fund it much better. And there's no constitutional right to have a well-funded public defender service in your jurisdiction. And so where it is well-funded, although they're still often overburdened, where the defenders are still, working their heads off with a tremendous caseload, et cetera, remember that, in fact, there are other places where the burden is even harder, even higher. And so many times local bar associations, particularly state bar associations, will lobby as a professional matter with state legislatures to try to increase funding for public defenders, to try to, at least to some extent, equalize the representation people get, and not eliminate, because that can't be done, but to minimize at least the distinction between the wealthy and everybody else. It's really everybody else, middle-class folks, and then, of course, poor people. And they also, by the way, the amount that's set to pay appointed lawyers is way too low. And that's set by local, I suppose that might even be set by county.
And when you use the term appointed lawyers, right, what do you mean? Because that's not a familiar term for everybody. Yeah,
I mean, let's suppose you're being arraigned in federal court, and the judge reads the charges and you plead not guilty. And the judge says, do you have a lawyer? And you say, I don't. And the judge says, have you retained a lawyer? I said, no, I don't have enough money. Either fill out a form. If you're below the poverty level, whatever, then it fluctuates, obviously, over the last 50 years, you will have a public defender appointed for you. If you're not that poor, and I'm talking about working people, right, but not poor enough to get a public defender, the court will have a list of lawyers who've made themselves available for appointment. That is, the judge says, looks at the list and says, let's take Ms. X. I'm appointing Ms. X to be your lawyer. Ms. X will come, you can meet with Ms. X, you can start your defense, she will represent you throughout the trial process at the very least, right? And she will be paid by Philadelphia County, by Allegheny County, by Cook County, whoever it is, but again, at a very reduced rate. Right. And so, and sometimes those are younger lawyers trying to get experience. Other times they're just lawyers who are just really good people. I mean, and represent people who need representation.
And sometimes those lawyers are appointed because of conflicts that the public defender has. It
Correct.
Could be, a few defendants, right?
Correct. If they're co-defendants, for example, in the same case, the public defender cannot represent both because that could be a conflict of interest. So one will get a public defender and the court will appoint counsel for the other one.
Right. Thank you. So there is a question about the title of the manual for police interrogation, but that you were referring to.
Now, the only question is, can I find it on my bookshelf? Or is it in my office?
Okay. So
we'll have to do.
We
I'll
can
send
we
it
can
to you.
send it, right? We
I'll
can,
send it to you and people can,
correct,
it's publicly available,
right.
but I'll send it to you and people can be informed from that.
And I know that there have been a lot, there's a lot, I'm reading the chat as we go along, and I know there's been a lot of references to different cases, different resources in the chat. So what we will do at PMC is gather these references, put them into a document, and circulate them as well. I want to say thank you, David, very much for your time, for your expertise,